And first, foremost limitations of judiciary in general. I'll talk about the general limitations, then I'll talk the issue areas. Issue areas, when I talk about, I will discuss about the current or some recent past related controversial aspect of judiciary. But here limitations, what makes judiciary less effective or what makes judiciary does not work to the level we expect. The first limitation of judiciary is the judicial principle of Suo Motu. Suo Motu या or Suo Motu, these are alternatively used. Suo Motu also, M-O-T-O Motu or Suo Motu. Okay, I'm listing, then I'll explain. Second limitation is the limitations of time. Limitations of time. Third limitation is lack of expertise. Fourth limitation is dependence on government machinery. Fifth limitation is cost of judicial process, poor man's burden. Sixth limitation is complexity of judicial process. Aura. Next is aura of the court. Or judiciary's pomp. Eighth limitation is colonial heritage. Ninth limitation is corruption in judiciary. Tenth limitation is accountability related issues. Now this 10 limitations, we are talking the general limitations of judiciary. But when I have to talk about the sorry, when I have to talk about the issue areas, like if I list the issue areas in judicial system, so first issue area comes in mind is judicial activism. Second issue area comes in mind the collegium and issue of opaqueness or opacity, lack of transparency, you can say. Third issue area is political inclination. Judiciary. Fourth recent famous area, the media oriented expositions of judiciary. Fifth, question on neutral component of. These are some of the issue areas we find recently discussed, debated. Okay. So some are major issue areas for which we have broader discussion. Some are lesser significant issue areas for which we have a shorter discussion. These issue areas are also pointing us towards the limitations of judiciary. Clear? So limitations, this point is also there. Now when we talk about these limitations, is very important to keep into mind. I think I should highlight them. What are they? Simply, we follow the Anglo-Saxon system of jurisprudence. We follow Anglo-Saxon system of judiciary. Under this Anglo-Saxon system of jurisprudence, judges do not go to person or victim. Victim or aggrieved party should approach the court. And this idea we know as doctrine of standing. When I'll talk about judicial activism, I'll refer to this point. That an aggrieved person should approach the court. Court will not take the matter by its own. Suo Motu means by its own. Means judge is passing through some street and he finds a criminal is murdering an innocent person. Judge goes to his home. Now judge cannot say that the family of the victim should come to police station, file FIR, or judge cannot call the police and both the parties in the court and punish. First, who is victim, he should say that I am victim. His family members, near dear, they should come to police, they should register FIR, then matter should come to court, then court will try. The court, even after seeing something, some wrong, court cannot take the matter. So it's very significant that court is not reaching the people and everyone cannot reach the court. There were earlier we used to have a crime rate higher, and now in comparison to that, crime rate lesser earlier. In comparison to that, we see National Crime Record Bureau's data. If you see of past 15-20 years, find that crime rate has gradually increased. We find that police has become more active, social media more vibrant, crime rate has basically came down. Why then National Crime Record Bureau register more, gives more data? Because today the registration of FIR has increased. Because people got educated, media becomes vibrant. Now people acquired resources, connectivity of village, rural and urban area increased. Social media plays a very revolutionary role in this regard, that something is happening, it becomes viral, everyone comes to know about it. Then criminals fear, and crime taking place, people don't fear, they go to police because they know if everyone is making videos, it will become viral and people will face difficulties. Earlier criminals used to bully down the victims, they threatened the victims not to go to FIR. Police formed nexus with the criminals or powerful people to not allow FIRs entry. Police also did not want to take up case so that it is a burden on them. So FIR registration was less. Why FIR registration was less earlier? Because people were weak. They had lack of resources. Powerful people could easily suppress the weak person. So when this is the condition, weak person can't approach court, they can't register FIR, they can't go to police or some machinery by which they will achieve the trial of that crime against them. So if court is not reaching the common man and common man is not able to reach the court, will justice be there? Prevalent of judicial system or prevalent of courts does not secure justice. Justice is not a condition only depended on existing of the courts. Justice depends on lots of conditions. Capacity in the people to avail justice is one of them. Vibrancy in the court system to approach the crime is second. So here Suo Motu principle was against justice itself. Now, you may say that Suo Motu idea now becomes redundant because recently this Suo Motu idea has been redefined by the principle called public interest litigation. A concept emerged, public interest litigation, PIL. Because of that, the Suo Motu issues come to court. How? I will discuss it separately. But PIL is related to very limited aspect of the judgments of the court. Even in recent years, court has started discouraging PILs. But PIL is a very good thing, is a revolutionary thing. It has transformed the nature of justice system. So, in a principle, basically, fundamentally, the justice system remains based on this Suo Motu principle. And it's a big limitation. Then comes limitations of time. Why this limitation of time becomes significant in case of India? Because of pending cases. More than 4 crore, according to some data, more than 4 crore cases are pending in different courts of the country. And thousands of vacancies exist in different courts, starting from the lower courts. So pending cases are there and vacancies in the court. Number of judges is less. So number of judges is less, judges are appointed less. So one judge, number of case becomes more and more. When more case is with a judge, then what he will do? So today he can take 4-5 hearings or 3 hearings, 4-6 hearings maximum. Then 5 days a week when he hears, then 20-25 hearings. And in 1 month it is not more than 100 hearings he can do. 100, 120, 125, but the cases are 1000, 2000. Then next date comes 4 months later, 5 months later, 6 months later. And you know, Tariq pe Tariq, Tariq pe Tariq is a very popular dialogue. Why this happens? So this happens because of the pending cases. This happens because of vacancies in the country. In our case, time is a limitation. And what is this limitation? See, delay in justice is justice denied. No? We say justice delayed is justice it's a big limitation of judiciary. Justice is delayed, it's equivalent to justice delayed. One reason why it happens because of the pending cases, vacancies. Second, it happens because of investigation related delays. Police conducts investigation, agencies conduct their investigation, and until they reach the final conclusion of that investigation, the case continues. Because in our system of judiciary, it's or Anglo-Saxon system, it is said that may the culprit gets free or may the culprit scot free, but it should never happen that an innocent is punished. The culprit may get free, it's okay, but innocent should not be punished. So justice system is a liberal democracy based justice system which does not allow the innocent to be punished. For this reason, investigation should be thorough, complete, extensive, in-depth. So if this is the reason, investigation process is more and more, judges also should hear things more and more times so that they are in position to proclaim the decree orders. So if this is one of the reason it happens, by reform the time factor can be reduced. Second, if it happens because of investigation related delays, then reforms in investigation can be done. Use of technology or filtration of the investigating officers or training to investigating team, putting the best officers for investigation, etc. can be the way by which the investigation process can be improved. So here in both the cases, reforms needed. And we shall study Law and Order Administration Unit 13 paper 2, we shall be discussing about judicial reform. Clear? Then comes the lack of expertise. So lawyers are, we say, this court in which the judiciary sit is ordinary court. Why it's ordinary court? Because they do not, or they are not meant for the expert purpose, specialized purpose. This is the reason tribunals are created. So judges do not understand scientific issues, technological issues, biological processes. They don't understand so many times the very complex technical aspect of administration. So expertise is a big limitation. This also lead towards delay. Now, this lack of expertise so many times make judiciary dependent on government machinery. Like police, the forensics team, whatever forensic team writes, that writing can be admitted in the court. So what findings police make, police when write those findings, that is admitted in the courts. IO is investigating officer in police, they what say is written. They go to spot, what they find, they write is written. The forensic team goes to spot, what they write is written. Or some murder post-mortem doctor writes is written. Doctor is corrupt, forensic team is corrupt, police is corrupt, and they write the wrong thing, judge has to accept. Now here we see corruption in police, corruption in legal machinery, law and order machinery, and these machineries are having nexus with the interest group, nexus with the criminals. My findings, suppose I am a detective, private detective, my findings, if not corroborated by government documents, court will not admit it. But finding of an investigating team of the government, verbatim as it is, whatever they say is written. So dependence on government machinery and limitations of government machinery, the problems in government machinery, corruption over there, nexus over there, these lead towards absence of justice in many cases. Means here comes biasness. Biasness. Here comes favoritism. Judiciary is not making biasness. Judiciary is not unfair. Judiciary is not making favoritism, nepotism. But in government machinery, this biasness, this favoritism, this nexus, this exists. If it is existing in government machinery, then justice will be influenced by this. Then comes cost of judicial process. It's poor man's burden. India is called lawyer's heaven. Lawyering fees is very high. One of my student is a lawyer. He appears in Supreme Court. He appears in high courts today. And he's every day, every appearing fees is 1 lakh rupees. He's a young lawyer. He is practicing for 6 years maximum. There are lawyers who are charging fees of 10 lakh rupees per hearing. They are there. Big names who are appearing for political parties or a sargana of political parties. They charge 10 lakh rupees per appearance, 5 lakh rupees per appearance. Not many law firms are there in the country. Even the politicians, the MPs and ministers, ex-ministers of the country, they have charged 10 lakh, 15 lakh, 20 lakh rupees. They talk about social justice. And imagine one lawyer who is having team of lawyers, 25, 30 lawyers as their subordinate, working for a party. And there is another victim, he is a poor person, he can't afford a lawyer. Even if he is able to afford, his lawyer is not so intelligent, not so capable. How there is a team World Cup winner and there is a team non-qualifier, they are fighting. And you say not just team, is an individual non-qualifier and a team, World Cup winner team, both are fighting in the court. Can there be justice? This process itself is injustice. That one lawyer firm having 25, 30s highly expert lawyers are fighting against a common man, a common man's lawyer who is not able to afford court fees. Court procedure is costly. Lawyer's appearance is costly. And that makes justice sometimes impossible for poor. So cost of judicial process poor man can't afford. Lawyering fees poor man can't afford. So rich people can afford the expert lawyers, capable lawyers, experienced lawyers, and they grow. They win the case. So is not a genuine fight, fair fight, justice compromised? This is not the problem with the judges, not the problem with the court, but it's limitation of judiciary. That they can't provide the equal fighters, equal argue persons or advocates in the court. They can't provide. Even our National Legal Service Act, NALSA, National Legal Service Authority Related Act, NALSA, which was mandated as per DPSP, Free Legal Ad, created. State Legal Service Authority is there. But there is huge corruption. Incapable lawyers, professionally not so competent lawyers. And that lawyers form nexus with the rich people. NALSA has not been successfully executed in the country. So its limitation. And judicial process is very complex. It's very complex process. Lots of documentations, formalities, paperwork, appearances. It's a stress. When people pass through that process, when they go to court, sit for 3, 4, 5, 6 hearings, poor person leaving their livelihood. Today they have to earn and maintain their food for today. But they have to go to court. They can't go because they have to earn their living for today. They have to earn for food for today. The people, lower middle class, even middle class people, they cannot afford this complex process. They don't want to go for the court system. And there is aura of the court also. Court has pomp, fear. That judge is sitting, there is a marshal each side. If I speak as a victim, I speak something, my words are written. If I could not speak right way, my words become wrong, my language become wrong, I may be punished. Police is there standing, I can be put behind bar. Such a pomp is maintained in the court that common man fear. Because of these reasons, people want out of the court settlement, out of the settlement. Family of a rape murder victim settles for 50,000 rupees, 25,000 rupees, sometimes 5,000 rupees. Family of a person torturously murdered by some powerful goons, they settle outside court without a penny, just to save their life. They settle. So people don't want to go because of complex process, because of cost there, because of judicial pomps and aura. They have a fear. And plus this thing is made more problematic by this corruption in judiciary. People fear maybe judge has taken money. Where shall I go? The corruption in judiciary prevail. We have lots of references of the corruption in the judicial system. We have the reference to Justice Dinakaran, Justice Sen's impeachment process, and others judges at lower level. Recently, I talked about Prashant Bhushan. He was consistently talking about the corruption in judiciary. I can recall an ex-Chief Justice. He belongs to Assam. He is presently Rajya Sabha member. So he was giving an interview in G News. So G News, Sudhir Chaudhary is a popular anchor who used to conduct DNA earlier. Chaudhary is a blunt lawyer, journalist. He was asking so many questions concerning the ex-Chief Justice. So one final question he asked from him, that what do you think, there is corruption in judiciary also? Then the reply of the ex-CGI was not that. He did not say no corruption in the Supreme Court also, he asked. His reply was not no. He said, ex-Chief Justice said, that judges do not come from heaven, they are also human beings. So ex-CGI cannot say that judge is corrupt or Supreme Court judges are corrupt. But if he is rejecting the claim that judges are not corrupt, or he is answering a question in this way, what can we deduce from that answer? But CGI also does not say that Supreme Court judges are immune from corruption, they are having strong moral integrity. He says they do not come from heaven, they are also human beings. It means human being can have those errors, limitations, then Supreme Court judges can also have that limitations. So lots of instances, there are lots of movies we watch, that movies are not without fact. They are based on logical arguments and existence of the fact that judiciary has corruption. So judiciary has corruption, and corruption is a very significant phenomena which undermines justice. And then colonial heritage, colonial law, colonial officers in the court, they are also organized the court system. They are also significant aspect of the judicial system. They have colonial mindset, colonial perception. They believe common man, poor, not as their masters, as their inferiors. That also affect judicial system. And then finally, accountability related issues. It is said that judges are accountable to none. They are just accountable to their own superior, and that also rarely. This Right to Information Act is not applicable on them. Their salary allowances, etc., cannot be audited, etc., by some agencies. Complaint against judges cannot be made in Lokpal, Lokayuktas. So for their amassing of wealth, income disproportionate to, the asset disproportionate to income, more asset, income is less, can't be calculated, can't be evaluated, scrutinized. And they give lots of wrong judgments. These judgments are reviewed by the courts, superior court. Court does not see why this judgment was given. Was there any personal interest, narrow interest, nexus, corruption, conflict of interest? So judges are accountable to whom? They are not accountable to any government, legislature, any government branch, legislature or executive. They are not accountable to people. And how they are accountable to people? Plus, conversely, they enjoy contempt power. So judges should be accountable for wrong judgments, which is affecting life of people. They should be accountable for biasness if deliberately done. They should be accountable for some conflict of interest in their rulings, etc. They should be accountable for any wealth, asset they have amassed through unwanted, undue, unfair means. They should be accountable for any other conduct which is grave injury to society, morality in public life, against the interest and welfare of masses or against nation. They must be accountable, and for this purpose there must be some significant law, and we don't have such law. We lack that law. And Lokpal system was conceived and Lokpal Act was passed, judiciary was outside. RTI keeps only very limited aspect of judiciary. Very limited components of judiciary is there in RTI. That also by Supreme Court rulings, that limited aspect. Especially Subhash Chandra Agarwal's cases. After that, judiciary had highlighted that these things can be made open to public. Clear? So accountability is a big component of judiciary's limitations. Here, public confidence in judiciary comes down. Judiciary cannot remain an neutral arbitrator. Judiciary cannot enjoy such a people does not have confidence in judiciary. When people have lack of confidence in judiciary, then this will lead towards a type of insecurity in the people's resentment, people recourse to other types of steps. When people go for mass movement, strikes and lockouts, when they don't have justice received through right means. So for good reasons, if mass movement is done or strikes and lockouts etc. are done, the question does not come to executive and legislature, the question directly comes to judiciary. So these are limitations and it can cost a nation big. Got the point?